No one should be above the law. And today's verdict sends that message. But it's not enough. We can't stop here.
That right there, President Joe Biden commenting after the Derek Chauvin murder trial verdict. With just over 10 hours of deliberation, Chauvin found guilty on all 3 charges in the George Floyd killing. Joining us now to discuss the man who's been breaking down this trial for us since the beginning, defense attorney and co-host of the Beyond a Reasonable Doubt podcast, which I recently discovered, Mark Geragos. Good morning to you.
Good morning, Rachel. How are you?
Doing well. Now, this is something we've been talking about for weeks. So first and foremost, now that we have a verdict, what were your thoughts yesterday?
Look, I've said all along, I think to you, so we've got the tape, that there didn't appear to be any way this was going to be an acquittal. It was a tsunami or tidal wave of public opinion and to some degree evidence that was allowed in against Derek Chauvin. I thought his best shot was a hung jury, and clearly 10 hours was about where this jury decided they were going to just come in and it was going to be a clean sweep on all 3 counts.
And now, Mark, there seems to be a lot of confusion surrounding the sentencing. The next step here, we have the verdict, and now we're going to sentence. You said on your podcast you believe Chauvin will be sent away for life. So how does that play out in regards to not only the different charges, but also the aggravating factors due to minors at the scene and the potential for an appeal? Can you explain this to us?
Sure. Minnesota uses a system that's fairly similar to the federal system in terms of sentencing guidelines. One of the things that you saw yesterday is after the jury was discharged, which means let go, the judge said, I want you to file your paperwork on the Blakely aggravating factors. That meant that the defense had waived jury for the jury to find facts either in aggravation or not, and they are going to let the judge decide this. So if the aggravating factors, and he's giving a scheduling order as to when they have to file it, if the aggravating factors are found, then the presumption of 12.5 to 20 years of the sentencing guidelines can move up. You can add time to that based on facts that the judge will find now sitting as the bench officer who's finding fact. Literally finding facts. If that's the case, and the prosecution will be asking for 40 some odd years or so close to 40 years, for all practical purposes, he's going to go away for life. And by the way, remember, appeals are granted in very, very small percentage of cases. So while it will be heard, it's unlikely that you're going to get any kind of appellate relief, at least on the state side or in the state system.
Okay, so when the discussion surrounding Congresswoman Maxine Waters' comments, also there was a lot of discussion. We showed what President Joe Biden said after the verdict, but he also spoke before the verdict, saying that he spoke with the family and was praying for the right verdict. Were you surprised that the president said that? Now, I believe his wording was, I spoke out once the jury was sequestered. However, right. The entire public was listening.
Yeah, that's true. And, you would hope that somebody who was the first former public defender that we've had as a president, albeit it was 50 years ago, would know better than to wading into that until afterwards. At least he was aware of the fact of the jury being sequestered or not sequestered. What Congresswoman Waters did, frankly, is inexplicable, and I join in the judge's bewilderment and angst over that. I think the idea, and I think the judge was reflecting also, he was talking about co-equal branches of government, because he was aggravated already at the beginning of this case with the executive branch announcement in Minnesota of the $27 million settlement. He lost several jurors because that was announced during jury selection. That aggravated him, and rightfully so. He tried to run a trial as tight a ship as he could, given the kind of daunting circumstances. And here you have politicians who are making hay on this for reasons that are, well, I guess explicable, but from a legal standpoint are aggravating, to say the least.
And Mark, when it came out that they were going to read off that verdict yesterday, it surprised a lot of people how quick it was. People instantly jumping to the conclusion, okay, it must come back guilty if it's this quick. And then people online were also quick to point out O.J. Simpson, which I know you're very familiar with, or the George Zimmerman trial, or Casey Anthony. Those all had quick deliberations as well, and they were all acquitted. Do you think in this instance the defense could have done anything different? Looking back at the way that the case was handled, the way it turned out, do you think they could have done anything different?
Yes, I think you always, as a trial lawyer, you rarely, if ever, think you tried a perfect case. You've always got second thoughts, especially if you were to lose. Remember, though, that O.J. Simpson, Casey Anthony, even Aaron Hernandez, those were all cases where the jury was sequestered during the trial. This case, the jury was not. That's going to be one of the chief arguments on appeal, that they couldn't protect this jury from outside influences, and that is it was basically a decision that was not based on the evidence in the courtroom, that it was based on public pressure. I mean, I would expect that to be in salvo in any kind of an appeal, but that's still months, if not years away.
Hey, I'm Rob Finnerty. Thanks for watching. If you enjoyed this video, please join the conversation in the comments below. Don't forget to subscribe, too. Hit the bell icon to be alerted to breaking news. And remember, there's a whole lot more on Newsmax TV, America's fastest growing cable news network. Newsmax TV, where real news for real people.